Parker Waichman has filed lawsuits both in federal and state courts, claiming serious and permanent physical damage to the retinas of its clients. Parker Waichman has retained some of the world's leading retinal specialists and others with extensive knowledge of Elmiron and its toxic effects on the retina. Anyone who's ever taken Elmiron and is suffering from one or more of the following: blurred vision, and I think we went over these earlier, blurred vision, difficulty reading, difficulty adjusting to dim lighting, problems with dark adaptation, glare, metamorphosia, blind spots, blindness, in my opinion, should see a retinal specialist who has the radiological tools, the imaging tools to confirm whether there is damage to the retina and if it was caused by Elmiron. Like I said earlier, the damage to the retina caused by Elmiron is what I would refer to as a fingerprint injury. That is, the damage to the retina that's caused by Elmiron had never been seen before Elmiron was available for sale. Parker Waichman represents clients in pharmaceutical and medical device cases in all 50 states. We're a national firm. We're a litigation firm. We don't collect cases and let other law firms do the work. We don't get cases and then refer them out. We litigate our cases. We don't sit around and hope the defendants will try to settle and then try to get in on a settlement. From our almost 4 decades of pharmaceutical and medical device litigation experience, we have found, without question, that the clients of the law firms that actually litigate their cases are more appropriately compensated than clients of law firms that sit and hope to piggyback on a settlement arrived at by others who actually did litigate the cases. In order to litigate the cases against giant corporations like we have here, I know that you can imagine, how do you do such a thing? How do you take on some of the largest corporations in the world? It must be very expensive. It is. It costs millions, tens of millions of dollars that we advance to the litigation. It takes an army of lawyers and paralegals. We have the army. Parker Waichman is well financed and has almost 4 decades of taking on the pharmaceutical and medical device manufacturers. And we know from firsthand experience that when you actually do the work, when you take the depositions, when you do the discovery, when it comes time for case resolution, our clients are going to benefit from that work. The attorneys at Parker Waichman have been involved in dozens of pharmaceutical and medical device litigations over the last 4 decades, starting with diacylstilbestrol, breast implants, Prozac suicidality cases, Fen-Phen, Zyprexa, Bauschalom, Renewit Moisture Lock, contact lens solution, which involved damage to the cornea, not the retina, Zyprexa, Orthoevra birth control patch, Yaz birth control, Medtronic infused spinal device litigation, TDF drugs, and so many others. In the Renew case, a lot of our clients had their cornea replaced, but unfortunately, you can't get your retina replaced. So well, that speaks to the damages. Everything that you tell us and that we tell you is confidential, highly confidential, and protected by the attorney-client privilege. That's why when you talk to your doctor, you talk to your doctor about medical things. You talk to him about problems with your vision. Talk to him about the time that you took Elmiron, the period of time you took Elmiron, whether you need to go see a retinal specialist. whether you need the retinal imaging that is able to diagnose whether you have Elmiron-related toxicity to your retina. But you never talk to your doctor about the litigation. You never talk to your doctor about things that we talk about. Because if you do that, while they originally were covered by the attorney-client privilege, you could be deemed to have waived that privilege once you start talking about privileged things, and we don't want that to happen. Another thing that's very important, and that we haven't discussed yet, is that the defendants are going to be asked, we asked the defendants for discovery. We asked them for their emails, their clinical trials, adverse event data, pharmacological data, all kinds of information. But they also ask us for information from you. They want us to look at your emails. They want us to look at your Facebook page. They want us to find any information that you've posted that would be relevant to this litigation. So I plead with you, keep everything to yourself having to do with this litigation. Don't post anything on Facebook. Don't be emailing your friends or relatives about your problems with your vision or litigation. This will be information that they will want, and this is going to be information that they're going to get. And they're going to use it against you as effectively as they can. So don't give them that opportunity. Keep everything to yourself, having to do with your problems, your eyes. Keep it off the social media. Keep it out of your emails.